Good morning, everyone, and welcome to HK45's Guide to Arbitration video series. My name is Eric Ng, Managing Counsel at HKIAC. In this video, we will talk about drafting dispute resolution clauses in contracts, or DR clauses in short. We'll go over why the drafting of a dispute resolution clause is so important, and some other points to consider when drafting your clause. A DR clause sets out how the parties intend to resolve any disputes that arise out of their contract, and it's basically a pre-agreed roadmap between the parties if disputes are to arise down the line. DR clauses are often referred to as midnight clauses, as they are added into the contract after the material provisions have already been finalized as an afterthought. When negotiating a contract, the parties are in a honeymoon period. During that early period, parties often do not pay much attention to the scenarios of what would happen if their relationship was to eventually break down. As a result, parties often do not tailor-make appropriate DR clauses for their particular contract. Yet time and time again, disputes arise, and then parties look to the DR clause for what to do next. Poor drafting of the DR clause can lead to complications and disputes about the clause itself, on top of the substantive dispute. On the other hand, a good DR clause helps parties resolve disputes more effectively and efficiently, both in terms of money and time. It also puts the parties in the driver's seat when a dispute arises. Courts and tribunals generally endeavor to uphold the terms that the parties have agreed. A well-drafted DR clause provides clear instructions to the courts and tribunals, allowing for a far smoother arbitration. The common methods of dispute resolution are negotiation, mediation, arbitration, and litigation. Negotiation is where the parties sit down and discuss between themselves a way forward. Mediation involves a neutral third party, the mediator, who is present to hear the disputes and work with the parties towards a mutually agreeable solution. Further down the spectrum are arbitration and litigation, where disputes are brought before an arbitrator or a judge in order to obtain a final and binding decision. Between arbitration and litigation, we are seeing more and more disputes being resolved through arbitration over the years. HKIAC received 265 arbitration cases in 2018, 308 in 2019, and 318 in 2020. Arbitration provides several advantages over litigation, including, for example, easier enforcement against assets compared to court judgments. There are limited circumstances in which an arbitral award can be appealed, therefore giving the parties more confidence in the finality of an arbitral award. Parties can also enjoy greater flexibility and confidentiality in arbitration. If parties choose arbitration, it is best practice to start with the model clause of an arbitration institution. This, for example, is the HKIAC's model clause. There are some features of the clause that I would like to highlight. First, it tries to capture a variety of different types of disputes, including non-contractual disputes. Second, it is an administered arbitration clause. While it is possible to opt for an ad hoc arbitration, which is administered by the parties themselves instead of an institution, this is often not an ideal solution when parties are unlikely to agree to various procedural steps for progress of the arbitration. An administered arbitration means that the HKIAC will have an active role in the arbitration, and parties will have the benefit of a well-developed framework for arbitration. Third, it includes an optional governing law clause for the arbitration agreement itself. Governing law clauses are crucial in contracts. However, there have, over the past few years, been a number of cases where parties have disputed whether the governing law clause applies to the arbitration agreement. This is because the arbitration clause is considered to be separate from the rest of the contract. As such, HKIAC's best practice recommendation is to include a specific governing law clause for the arbitration agreement. Fourth, it includes the option for parties to choose 1 or 3 arbitrators. Each approach has its pros and cons. A single arbitrator has much more control over the proceedings, which can be beneficial, but it is also necessary for parties to ensure that the most appropriate arbitrator is picked, as there are no co-arbitrators to rely on. 3 arbitrators can mitigate against risks arising out of this, but one disadvantage is that proceedings with 3 arbitrators may, on average, take longer to complete because of scheduling issues. After starting with the framework of a model clause, parties should consider whether they need to tailor-make it to their own dispute and whether they need additional options. An arbitration clause can be more expansive than the above. The parties may decide to include, for example, provisions on whether the parties wish to adopt best practice guidelines, such as the IBA rules on taking of evidence in international arbitration, or the Prague rules. The parties may also consider whether provisional or interim relief could be sought from a court of competent jurisdiction prior to or during the arbitration. While language in an arbitration clause should be specific enough to identify what it is referring to, parties should also take care not to be too specific by mandating, for example, strict or specific time periods in their arbitration clause. One example of this drafting mistake is requiring, for example, appointment of arbitrators within a specific time frame, such as 14 days. Whereas institutions such as HKIAC would be able to extend time limits that are in their institutional rules, where parties agree to specific provisions in the arbitration agreement, it is unlikely that the institution will be able to override those provisions, and it may be difficult for the other side to agree to an extension once a dispute arises. One commonly deployed option is the use of a multi-tiered clause, which provides for a dispute to move forward in stages. For example, a typical multi-tiered clause would provide for negotiation first, followed by mediation, followed by arbitration or litigation if either of the previous two methods fails. A good multi-tiered DR clause will usually include clear time limits so that the parties know specifically how long they have before the dispute progresses to the next stage. A multi-tiered DR clause should be drafted with certainty. Care must be taken in making clear whether each step is optional or mandatory. An arbitral tribunal may find itself lacking jurisdiction to hear the dispute if the previous tiers are mandatory and the preconditions for arbitration have not been satisfied. Alternatively, one party may argue that the arbitral award is not valid because of such lack of jurisdiction. In a court setting, the court may stay the proceedings. For example, if a clause states that parties shall commence mediation and only upon failure subsequent to a mediation lasting not less than 3 hours may parties commence arbitration. But there has been no mediation. In such a situation, a tribunal might find itself lacking jurisdiction. If drafted carefully, a multi-tiered DR clause can provide parties with ample opportunities to explore different options first, which can save costs and create favorable win-win scenarios as opposed to arbitration or litigation. A badly drafted multi-tiered clause, on the other hand, can bog down or delay proceedings. Other options that parties may consider including are the DR clause is often left near the bottom of the contract and regarded as a boilerplate clause which can be done by a simple copy and paste of the standard wordings. However, parties that do this are walking without a wire, hoping that the contractual relationship will be successful without adequate protection in the event that it is not. DR clauses are bespoke, and there are often specific considerations under the contract which affects the drafting one way or the other. We have summarized the following takeaway tips for you. First, a DR clause is necessary in a contract, and it should be specifically drafted. You may want to seek legal advice when doing so. Second, there are different methods of dispute resolution, for example, negotiation, mediation, arbitration, and litigation. You should consider which best suits your needs, especially between arbitration and litigation. Third, while it is possible to layer different methods of dispute resolution, it is crucial to draft DR clauses carefully and clearly. Fourth, consider your DR clause comprehensively and consider whether it should include a governing clause and a jurisdiction clause or an arbitration clause. Thanks very much, everyone. If you'd like more information or videos about arbitration in Hong Kong, please visit HKIAC's website and stay tuned for other videos in HK45's Guide to Arbitration video series.